students, welcome to Learn to Live. In this video, we'll be discussing about the case Carlill vs. Carbolic Smoke Ball Company. The defendants, who were the proprietors of a medical preparation, Carbolic Smoke Ball Company, advertised in the newspaper as follows. £100 reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the increasing epidemic influenza after having used the smoke ball 3 times daily for 2 weeks according to the printed directions supplied with each ball. £1,000 are deposited with the Alliance Bank, showing a sincerity with the matter. The plaintiff, relying on this advertisement, purchased the medicine smoke ball and used it. She used it 3 times a day for about 2 months, starting from 17th November 1891 to 17th January 1892. Several weeks after the plaintiff began using the smoke ball, she caught the flu. The plaintiff, Carlill, filed a suit against the defendant company claiming the reward as advertised. The company contended that their offer was specific offer and they did not offer to a particular person, that is Carlill, and that she did not signify her acceptance to them, hence no contract was arisen between them and her. Brief fact summary. The plaintiff, believing defendant's advertisement that its product would prevent influenza, bought a carbolic smoke ball and used it as directed from November 20, 1891 until January 17, 1892. When she caught the flu, plaintiff brought suit to recover £100, which the court found her entitled to recover, and the defendant appealed. Synopsis of rule of law. This case considers whether an advertising gimmick, that is, the promise to pay £100 to anyone contracting influenza while using the carbolic smoke ball, can be considered an express contractual promise to pay. Facts. The defendant, the Carbolic Smoke Ball Company of London, placed an advertisement in several newspapers on November 13, 1891, stating that its product, the carbolic smoke ball, when used 3 times daily for 2 weeks, would prevent cold and influenza. The makers of the smoke ball additionally offered a £100 reward to anyone who caught influenza using their product, guaranteeing this reward by stating in their advertisement that they had deposited £1,000 in a bank as a show of their sincerity. The plaintiff, Lily Carlill, brought a smoke ball and used it as directed. Several weeks after she began using the smoke ball, the plaintiff caught the flu. Issue. Lord Justice Linley, on behalf of the Court of Appeals, notes that the main issue at hand is whether the language in defendant's advertisement regarding the £100 reward was meant to be an express promise or rather a sales puff which had no meaning whatsoever. Held. Defendant's appeal was dismissed. Plaintiff was entitled to recover £100. The court acknowledges that in the case of vague advertisements, language regarding payment of a reward is generally a puff which carries no enforceability. In this case, however, defendant noted the deposit of £1,000 in their advertisement as a show of their sincerity. Because defendant did this, the court found their offer to reward to be a promise backed by their own sincerity. Concurrence. In the concurrences of Lord Justice Bowen and Lord Justice Ale Smith, the notion of contractual consideration also becomes an issue of relevance. Both of these judges note that while the defendant could argue lack of consideration, plaintiff in buying the carbolic smoke ball and using it as directed provided adequate consideration through the inconvenience she experienced by using the product. Discussion. This case stands for the proposition that while sales puffery and advertisements is generally not intended to create a contract with potential product buyers, in this case it did because the defendant elevated the language to the level of a promise by relying on their own sincerity. Students, this is the end of the section. Please like, comment, share, and subscribe the channel. Make sure you press the bell icon for latest updates.